Hello, David. Welcome to my podcast, Ask an Attorney with the Attorney's Guide. You've been here before. This is actually your third episode. Congratulations for having so much wisdom. I wanted you back 3 times. It's fantastic. And not to mention, I love how you communicated. So many people in intellectual property law, I think, come across as very dry, but you have been asked back 3 times on demand because you convey what you know in such a warm, welcoming, and friendly way that I appreciate it. And our audience does as well. But David, I'd love for you to start off and tell us all about you and how and why you got into intellectual property law.
Right. Yeah, it's I always describe my history as being odd because I was a professor of mathematics for 3 years and a software engineer for 12 years before even thinking about going into law. And the only way that I went to law was because of the technology and being a way to stay involved with technology and be involved with lots of different technologies. And it's been great.
God, and how long have you been an intellectual property attorney?
Since 2007, so almost 20 years.
Wow, you are going to have a very special anniversary coming up in a short 1 year left to hit that special mark. So I want to go into the most topical thing that everybody wants to know about. AI. So many business owners are encouraged to use it, have started using it. I never thought I'd see the day that I would use it, but I am. You can't get away from it, and I love learning about it. And of course, you how to deal with hallucinations, AI delivering information, acting that it's factually accurate and it's completely fabricated. So I want to know first and foremost on that, because so many people talk about hallucinations. Does that come into play at all when it comes to, well, intellectual property as a concept means you're protecting something unique. Well, does that take into consideration the concept of AI hallucinations when it comes to protecting something uniquely involving AI in IP?
Yeah, that's so AI is let me see if I can rephrase the question is essentially AI is as a brand new tool that people are using in intellectual property in many different ways. And what are the positive benefits of using AI, and what are some of the downside risks? And particularly, we all know about the AI hallucinations, and how does that affect things? I think that's kind of what you're asking about.
Affect intellectual property, since intellectual property means you're protecting something unique. But if AI is presenting something as fact that is completely fabricated, does the concept of intellectual property law take that into account when incorporating anything at all having to do with AI?
Right. So so the question there is like, well, if AI is contributing to an inventive concept, does that affect, well, what we can protect? And the answer is yes, of course, that it does affect it in a variety of different ways. And let's see if I can at least address some of them first. First of all, um, uh, so some people are using an AI system to essentially help them invent. And if the AI system is helping them invent, then that brings up a couple of issues. One is like, well, even assuming that it's like everything that the AI system creates is entirely correct, that's one issue. And the other is, well, what if it says something that's wrong? And that's a separate issue. And I think that's the question you're starting off with. And so and that's, yeah, you could file a patent application that has fabricated stuff in it. You could file that application. You could even go through an examination process. You might even get it allowed. Um, and then it's like, well, but if you try to enforce some rights, you might not be able to, because it's like, well, it's not legitimate. And
I
so
was wondering. Because to me, I think it's completely confusing how you have something as allegedly advanced as AI, but yet they're fabricating complete information and then presenting it so factually, you just assume a computer knows everything accurately. So
Yeah,
that's when it comes to protecting it. How does that even make sense to me?
right, and that actually happens even before AI. There are patent applications that have factually inaccurate information. So people have been fabricating things for a long time, even before AI did. We got
That's
there
so
first.
true, but AI is supposed to know better. It's a computer. It literally says artificial intelligence. You'd think everything coming from an artificial intelligence would be accurate. But then when you
Um,
come into law, what do you do?
yeah. So yeah. So the question is like, what do we do with the fact that that AI is creating some uh, inaccurate information? And probably the most important thing for both inventors and patent attorneys to recognize is that we can't rely on the accuracy of the AI systems, and therefore we have to review it and evaluate it with a critical eye. And I have a really good example of this in the last a few months. I have a client of mine that I've uh, pro, filed quite a few patent applications for over years, and he's got a bunch of very good patentable ideas. We've got patents, but this newest invention had asked him some questions about it, and so he sent me he sent me a figure as well as a figure, and so I thought that he had created it himself, and so I was trying to figure out what was going on, and it took me a while to realize that it wasn't my client, but it was an AI system that had generated this figure. And that's why I couldn't figure out what it was doing because it didn't make sense to me. So I was imposing reasonable, oversight to say, well, what does this mean? And it's like, it was illogical. It was just, particularly with my background in mathematics, I mean, I was looking at this mathematically and it was a graph and I was just, it's like didn't make sense. Uh, Once I realized that it was AI generated, what so basically I ended up just throwing it away because that generated image didn't it wasn't meaningful. And I was based upon the words that my client had written, that I was able to get meaning from that, and I was able to create my own figures and be able to convey it. And so I think that's the key thing is like in this case I was a little bit out of loss because I didn't know initially that it was AI generated. So
Oh, you.
yeah, so the client just gave it to me. So that's so it's helpful if I know that something's AI generated because I'll be more careful at the outset because this time I spent more time just thought, oh well, this is a smart guy. Why would he be writing this stuff up? And so I think so the key point is that whenever we're looking at AI generated content, we have to be critical of that, so our critical thinking skills are going to be tested more than ever. And that's something that I really emphasize to people. Just like be critical of everything. We have to.
Especially, unfortunately, if your client is coming to you and hiding the fact that he wants to, or she wants to protect something that's AI generated.
Yes. Yeah. So that's another a good question. Is like, well, what can we protect if something is AI generated? And I think let's actually talk about that question from a standpoint of two different things. One is uh, copyrightable material and patentable material, but the results are similar. So first question is like, okay, let's suppose that you have AI generated content and you want to get a copyright, and the answer is you can't get one. It's like
Create
now
it.
yeah, you just can't, you can't get it. It's not considered, um, the human generation is considered an essential element under current law. That law could change, but for now, people have to, there has to be it has to be human created. So if so this was there've been multiple examples of this, and one in the earlier podcast I talked about um, the artwork that was generated for the fair in Colorado. It's like, yep, it was AI generated, so no copyright. There's also another recent case of a book, Zarya of the Dawn, and the author had written a bunch of words but had AI generated images to go with it, and so the copyright office said, well, you can get a copyright on the work as a whole, but those images are not copyrightable. So that's the state of law regarding copyrights of AI generated images.
David, I know we delved directly into AI related topics, but you did reference the prior episodes that you hear on Ask an Attorney with the Attorney's Guide, which brings up the very important topic. Everybody listens to episodes independently. So, can we take a breath and take it back a step? And can you just please go over the four types of intellectual property and very briefly for those who haven't watched your previous two podcasts?
Oh, sure, yeah. It's a good idea to review what the four main categories of
Just
intellectual
for those
property
who
are.
haven't seen the other ones.
Yeah. So for the first main category of intellectual property is copyrights. Copyright covers any sorts of original works of authorship, which can be writings or music or artwork or any sort of creative original works. Then you've got trademarks, and trademarks are individual marks that are associating goods or services with that mark. And a couple of the are well-known examples of, say, like the Coca-Cola brand. That is a well-known trademark. And then
And
there's
Nike, I think we talked about Nike,
and
Disney,
Nike as well. Yes. So with
KFC.
Nike, yeah. And then there's patents, and patents will cover inventions that are new and not obvious. And the fourth type is trade secrets, um, which is broader than inventions because it can cover any sort of information that has a business value because of the fact that it is secret. And that's so for trade secrets, it's just like you keep a secret, and it can be anything of business.
I need to ask you something really quickly about trade secrets. As you know, there's a lot of different business coaches out there. What about when someone wants to share their trade secret with their business coach? Could they do that by requiring an NDA, do not disclose document? Can they protect it that way as well to make sure they could still work with the business coach? However, they still need to keep the trade secret a secret.
Yeah, that's a really important question about if you have a trade secret, what things do you need to do in order to keep it secret? And one of the things is a non-disclosure agreement. An NDA would be a very important way to do that, because if the question for a trade secret is, have you made it public or not? And if you've got an NDA in place, then the parties have agreed that they're going to keep that information limited to the specific person and for the specific purpose. And so you're keeping your trade secret protection if you have an NDA in place. So and that's going to be really important if you need to talk to anybody, whether it's your coach or any other person. I mean, about the only one exception that you don't have to worry about an NDA is with an attorney. There's an inherent attorney-client privilege, so it's protected in that way. But I still have some of my clients. I've had prospective clients still want me to sign an NDA, and it's like, that's fine. I'm not gonna steal this, so I'm fine to sign an NDA. Even an attorney can sign an NDA if they want to.
Well, really important though, A lot of new business owners, they're going to create a business plan and then go to a source of funding, whether it's an angel investor, a traditional brick and mortar bank. What about those situations where they're seeking funding and those funding sources are going to want to know their trade secret or the inner workings of what makes that business worthy of a loan or a grant or an angel investor becoming involved or traditional investor becoming permanently a part of that business by buying in shares?
Right. So, so the question is, well, how do you protect your intellectual property while at the same time being able to disclose the information to prospective investors uh, because they
Or
need to know that
lenders?
information. Yeah, and and um, that happens all the time. Yeah, and so NDAs are a simple way to do that, and NDAs some can be very long, but they don't have to be very long. The main thing is you want to identify what the information is going to be disclosed, and you want to state what the purpose is, because you want to say, who are you disclosing to? They're say limited to using this information for the purposes of evaluating investment or something. You want to be specific on what the information is and what's the purpose, what's the time frame. So an NDA does not need to be long. And in fact, an NDA is something you can get a pretty good NDA generated by one of the AI tools. You could say, hey, AI tool, generate an NDA for me for this, and it's like, I've seen it done. They're perfectly fine. They can do it, and because the content of an NDA is pretty well known, there's very little risk of an AI tool hallucinating on that, because it's like okay, it's just what are the key things you need. So that one's a pretty good use of AI.
Speaking of using AI, should they be using AI? And so instead of using an attorney such as yourself, which I personally would prefer a human, or should they utilize AI to file for any patents, trademarks, any type of intellectual property protection to circumvent using an attorney? What is the pros and cons of that?
Yeah. So the question is, well, since AI tools are inexpensive or free, why not use that rather than paying an expensive patent attorney? I mean, and from a cost perspective, it's like, well, paying zero versus a bunch of money, that seems pretty clear. Um, but there's significant downside risks to doing that, because it's actually similar to say, if let's suppose you have some sort of medical condition, are you going to say, oh, let's let AI diagnose me and administer drugs or something? It's like, I think I'd prefer to have a real doctor, doing something like that.
Imagine doing that. I can't keep a straight face, David. That's hysterical.
Yeah. But anyway, in the same way, a patent attorney does have specific knowledge about what's required for a patent application, and also, and a really essential part of a patent application is the patent claims, and the how you draft the patent claims is going to completely determine the scope of your patent protection. So having an experienced patent attorney draft the claims for you is a critical thing. A third thing the patent attorney does is the patent attorney communicates with the patent examiner. And I think some people don't realize how important that relationship is between the patent attorney and the patent examiner. It makes all the difference in the world in terms of communicating what the invention is and figuring out what needs to be done in order to get a good patent application allowed. Going back to the question is, well, what's the downside of just try say, I've got an idea. Here's an AI. It writes up an application for me. I file that. Um, then, well, then what happens? there's a number of things that can go wrong with that. And one example that I have seen just recently was a person who did essentially that, and 10 years later, he's still working with the patent office to try to get something allowed. And the problem is, it's like, it's without a
Did you say he used AI 10 years ago?
well, in this case, he didn't use AI, but the same issue, the same issue applies, was that he didn't consult with a patent attorney. He was just trying to do it on his own. Yeah,
Oh,
yeah. But more recently, we have people who are, say, using AI to do it, and that actually is even worse because there's more likely to be the language that AI generates tends to be vague, and vague is the opposite of what you need for a patent application. You've got to be providing technical detail about how things operate, as opposed to using general language. And that's what AI generates, language that sounds pretty good, but it's doesn't have the sort of detail that a good patent attorney would do.
well, I just want to see if we can dig a little deeper because I have some other questions that were
Sure.
submitted and we need to go forward with that. So, in some cases, inventors rather do get their patent applications allowed. Are there any problems in that case?
Oh, yes. So this is dealing with a slightly different example. It's like, okay, so let's suppose that an individual inventor um, files an application and actually succeeds in getting it allowed, and you say, sounds good, right? They prepared the application, uh, maybe with AI, or maybe by themselves, but and they've got it allowed, got a patent, except that that patent might not actually be very useful. And I saw this recently, where an individual inventor had filed a patent application, had gotten allowed, and then only after it was allowed was I contacted, and they said, "Oh, and I'd really like to enforce these rights against some of their competitors." And
Oh,
so, that seems good. If you've got patent rights, you should enforce them. And and I read the patent claims, and unfortunately, there were two major problems with the patent claims. Uh, some parts of it were way too broad, and some parts were way too narrow. And so it's like, yeah, yeah. So it was,
it didn't have consistent language throughout?
well, well, sort of like describing some elements in minute detail and describing other elements in just like these broad, vague terms. And so basically, it would have been impossible to actually prove infringement. And so, yes, they have a
Ah,
patent, but they couldn't prove infringement.
which
And so,
basically defeats the purpose of getting a patent if you can't use it to defend and claim ownership to those details.
absolutely, that's right. So a patent that is not written well is literally worthless. And unfortunately, there's a lot of patents that are of that quality, that are worthless. Um, so anyway, doing it by yourself can lead to, even if you got an issued patent, the results can be bad, because it's like, well, you'd never be able to enforce those rights. And so I think the risk of using AI is that one of the things that's like, when I read the output from AI, it's like the language is so good, it's well written, and I'm led to think that therefore it must be well thought out, and that's not necessarily true. And so we have to be very cautious about our use of AI. Um, but on the other hand, and this is one thing I wanted to bring up, is rather than having AI draft your patent application, AI can help inventors describe their invention. And that's so I call that AI assisted invention disclosure. And because it's like, let's suppose an inventor has an invention, uh, but they may be having difficulty expressing it. And so there are some tools now that are like having a chatbot like interface that can then say, read in your just whatever you've written up right now, even if it's a little bit, and then interactively prompt, rather than having the user prompt the AI system, have the AI system prompt the user to say, hey, tell me more about this element. How does this element relate to that element? And that I think is a very useful use of AI. And it's not something I have to worry about hallucinations, because the AI system is just helping a user explain their own invention. So that's
So
one example I think is a great use of AI.
So I think that how I hear you is that instead of using AI as the tool to submit the application, there you're using it as a tool to create components of the submission. Does that
Yes.
sound accurate?
Right, and that those components are then given to the patent attorney, and so that it actually enables the patent attorney to do a better job, because we have a more thorough disclosure. So that's an example that I think is just it's a win-win-win. It's like it's beneficial for everybody. And I'm currently working on deciding what tool I want to use for ourselves.
So I have really kind of part two or B, if you will, of that. So you have likened AI to kind of like a do it yourself. So on that, and why use an attorney instead? Because I'm all about understanding the pitfalls of do it yourself. Because you have mentioned several times already, there's parts that you should do yourself. But then when should you use an attorney like yourself, like you, David?
Right.
So now I'm wondering, all attorneys, and I want to verify this is the same for intellectual property attorneys. Do IP attorneys need to have insurance as in, oh my God, I just blanked out, a PNC insurance as in not
Oh,
property and casualty, but
yeah.
the,
Uh,
um,
yeah, a professional liability insurance.
yes,
Yeah, yeah,
liability insurance.
yeah, yeah,
IT attorneys have to have liability insurance, right? So if you lose a lawsuit representing a client and you are deficient in some way that hurts your client, correct?
yeah, yeah. And so yeah, the question about what type of liability insurance. So the key issues where liability insurance is relevant to IP attorneys is if the IP attorney misses a deadline, because there's some deadlines that's like if you miss it, you're just out of luck, and it's like you can't. There's nothing you can do to fix it. Uh, and so in that case, it's like, well, yeah, the law firm failed to do this when they were supposed to. You can't fix it, so you're gonna just have to see if the insurance can pay them money.
Another aspect, and this is what I'm curious about. So, when people are thinking, why use an attorney versus do it yourself? But you just mentioned, so if I was going to file a patent myself, for example, or trademark, whatever, well, let's stick with patents. If I were to file a patent myself, what if I make a mistake? Then I don't have recourse. But if your attorney, your intellectual property attorney, makes a mistake, you as a client would have recourse because the attorney has to have professional liability insurance, correct?
Right, right. And I'll say a little further on that is like, so the question is like, well, comparing do it yourself versus having an attorney. Um, um, First, so your point is that yes, an attorney is going to have liability insurance. So if they do make a mistake, yeah, you can get covered. But I think more importantly than that is that any good patent attorney is also going to have a system and people in place that make it far less likely that they will make a mistake. And so, like on my team, I have a docketing director. He has a docketing system, and so the probability that I would actually make a mistake is very, very, very low. So whereas if you're trying to do something by yourself, it's like, well, you don't know about everything. It's like your probability is much higher if you're trying to do something yourself. So I think it's probably most important is just like where your a patent attorney is far less likely to make any sort of mistakes, these sort of costly mistakes, because there's systems in place to prevent that. And the liability insurance is just sort of a backup in case of catastrophic failure for it can happen, but it's not so frequent.
But I think it's also important because remember, the whole purpose of getting the trademark or, the patent is to protect if someone else uses it and protect for infringement. But if you're doing it yourself and you make a mistake, then you're not going to be protected for exactly the initial purpose that you're getting it, which is for infringement. Is that accurate?
Right. I was to the purpose of intellectual property protection is ultimately to enforce those rights against others. That it's like, oh, you've got the rights to this invention, you've got this rights to your trademark, you've got this rights to your copy, whatever you're protecting. And the essential element of that is you better be able to enforce those rights. So will you be able to enforce those rights in court? And that's important to understand how the court systems work to enforce your rights.
I would love to go now into rights enforcement in court. So I have a few questions about
Sure.
that, if we could go diving into that area. So firstly, we know that intellectual property enforcement and litigation can be really expensive. Can we discuss the ways that AI can reduce those costs? As the first step of enforcement is identifying possible infringers. Can AI help with identifying possible infringers?
Yes. So yeah. So the big question is like, can AI help with litigation? And that's because it is so expensive. That means there's a lot of opportunity for cost savings, and AI can do a lot of things to help reduce those costs. And one that I've seen already, which is the question you just asked, was like, well, can AI help identify infringers? And the answer is yes, and it can do it pretty quickly. For example, I have a colleague who's a litigator, and I was just talking with him recently, and he was saying, yeah, so a patent holder they have some patents, and they literally asked one of the AI tools to say, find some infringers for me and generate some claim charts to prove their infringement. And
Wow.
so the system goes out there, identifies these. I mean, it can scour the internet, get the data. By reading the patent or patents that it's got, it's like, okay, this is what we're trying to find. Finds the possible infringers and generates claim charts. It says, okay, for this patent claim, I've got this element. Oh, here's where they do that. So generate your claim charts. And in fact, you can even generate the essentially the demand letter that says that you can send to this prospective infringer and say, hey, here's your infringement. I think you need to pay us X number of dollars.
So
So that is happening right now, and particularly with the non-practicing entities. If you're familiar with non-practicing entities, it's a business entity that buys up patents and then enforces those rights. And so their whole purpose is to monetize patents. And so yeah, it's like identifying infringers and and demanding payments from them is that's the business model. And so it works great for that.
it sounds like AI could be used in that respect to help the patent holders find those infringers, go after them, and generate revenue.
Absolutely. Absolutely. And as I say, that is happening now. It's not hypothetical. That's happening already.
So if someone is sued for patent infringement, can AI help in those responses?
Yeah. So now this question is, well,
It's the opposite flip.
it's the opposite. It's like now somebody else has sued me. oh, what am I supposed to do? So there's two things. If you are sued, there's kind of two routes that, and usually you pursue both. One is to say to prove that you're not an actual infringer, but the other alternative is to prove that the patent is invalid. And this is maybe something that may not be well known to lots of people, but um, the examination process is imperfect. Examiners have a limited amount of time and resources, and so there are patents that are issued that are actually invalid because the examiner didn't find some other relevant prior art. So it's like, oh, this shouldn't actually issue. So what AI can do, so if you're the person who is sued, you can say, ask the AI system, hey, can you find me some prior art to invalidate this patent? And once you found it, generate a claim chart to prove that it's invalid. And so the same colleague who was telling me about the AI infringement analysis also told me about that. And so he worked on the defensive side, and so they used an AI system to generate exactly that, and they sent the letter back to the person who had made the demand, and it said, well, in fact, your patent is invalid, so therefore, why should we pay you any money?
That
And
sounds
so,
like an excellent reason why to have an attorney, because then if your patent that you filed yourself and created yourself isn't validated, you can now be opened up for financial liability because you wanted to save a few $1,000s. So I know this is completely arbitrary, but can you give a rough ballpark of what they could be demanded as a payment? What they thought they were saving, and now they have to out of pocket it because they saved a few $1,000s on the attorney?
yeah. So the question there is
I
like,
know it's a
well,
huge span, like as an example.
yeah. So I think it's useful to think of that question on both sides. So the question is, what could be the downside cost of not having a patent attorney to represent you? And so if it's your own patent that you get and you're not able to enforce it, then your downside is that you may not be able to recover any money for anybody's infringement, and therefore your downside is, well, how much money could you have made from being able to enforce your patent rights, and now you're not able to enforce it at all. So whatever that number is, it's now gone to zero. And so
Completely
that's huge.
arbitrary.
Yeah. And then on the opposite side,
I'm
too,
like,
yeah,
wow. I can't believe it blows my mind how that complete possibility has been negated because they were looking to save a few $1,000s by doing it themselves versus hiring a professional, an attorney.
yeah.
Completely invalidate the possibility. They have absolutely zero protection. But also on the flip side, if they're the infringer, they're now sued and open themselves to liability.
Yes,
That's an
that's
unforeseen amount. It's completely arbitrary how much that amount could be.
right. So yeah, so that's the situation there is, if you don't have patent rights yourselves, then you're at greater risk of being uh, uh, having to pay somebody else to for infringing their rights. Um, and just as a good example, there is um, when both parties who are in conflict, if they both have patents, then usually there's some sort of a negotiation happens, and in many cases it's just that, okay, we'll just walk away and nobody pays anything. But if one side has patents and the other does not, then the side with patents is going to get some money.
Oh
And
wow! So that's why you should never shortchange. The pound of the. I know it's the ounce of prevention, but to me it should be like a pound of prevention because we're talking metric tons could be the
yeah,
penalty
yeah,
instead, which is why they should seek you out.
yeah. And I wanted to give one really good example I had a few years ago. Was I had a client, and our client was, um, we received a letter from a very, very large tech company that said, hey, we think you are infringing our patents. We think you should pay us, as like 10 or $20 million. And I looked at the patents, and it's like, these are garbage. I mean, worthless patents. But they wanted, like I said, 10 or $20 million. So if we didn't have any patents, we would have been in bad shape. We would have had, the client probably would have had to pay that. It's like, well, you have no. Fortunately, our client had some patents that I had worked on, and so what we did was then we said, okay, this big tech company also has products, and redrafted claim charts to show their infringement of our patents, and then we presented that to them. And so now we were on close to an even footing, even though this other company was much bigger. And there was some ongoing negotiations, and then it basically it just went away. And so our client did, basically saved 10 or $20 million because of the fact that they had their own patents. And it's useful to see this too, because they were using the patents in a completely defensive way. It wasn't like they went actively trying to make money off it. They were just said, oh, somebody is suing us, we can use our patents to defend ourselves, and it was effective. And so I think that's a useful example for people to be aware of, is that using your patents defensively against other players can be incredibly valuable.
And that's where I love that example, because it shows in that case, it seems like a David won against a Goliath because David was smart and got an attorney.
Yeah, and had a good attorney. Yes, had a good attorney who prepared
The
some
attorney's named David.
Did, yes. Yeah. So yeah, I think
Could
that's
not help that.
yeah.
Uh, but David, we literally have 3 minutes left, and I want to get real quick two more questions in before the
Sure.
time is up. So we talked about that, and really quickly. So we talked about non-fragment is of it work made for hire. Is that something that people can handle? Because there's so much with Fiverr, with hiring people from the Philippines, with all of these remote staffers. So if somebody's having work done, so let's say, for example, it's having somebody who they hire as a remote staffer in the Philippines, for example, because there's a lot of that going on.
Yeah.
And they have them design their logo. So now, can they submit that logo for, because that falls under work made for hire, can they file that logo under protection for AI, even though it's not technically created by them, but by someone they hired?
Yeah. So there's several questions in there. So first of all, works for hire are generally copyrightable material, and works made for hire is something that's is well known. You just say, as part of your agreement, you say this is a work made for hire. And so, for example, let's suppose that I asked you to generate something for me. We could say, okay, this is a work made for hire. I'm going to pay you X number of dollars. You generate this for me, and I can actually file for a copyright in my own name because it was a work made for hire. So that doctrine has been around for a long time. That doctrine has not yet been applied to AI, but I think it may in the future, because it's like, well, it seems like I could say, yeah, rather than reaching out to a person, I could reach out to an AI system. Please generate this for me. It hasn't been applied yet. I think it may in the future.
So real quick on AI. So I have one last question, because we are now down to the last 60
Okay.
seconds. One
Okay.
last fast question. It can take a long time to get a patent application allowed. Is there any way to expedite it? And does
Yes.
using an attorney help you expedite it versus doing it yourself?
Yes, and I actually strongly recommend it. So the question is, can we expedite a patent prosecution, the process of getting a patent? Because the process is very slow right now. It'll take, under normal circumstances, it takes about 2 years for a patent examiner to even look at it. First time, just like 2 years to look at it. There's the process called track one, and if you file an application under track one, then an examiner is actually going to look at it within 2.5 to 3 months. And the results on that have been very good. So So
You need an attorney for that. You go from
yeah,
2 years to 2 months. That's worth the cost of an attorney. I've got to tell you that you are amazing. I so appreciate you coming on for not one, not two, but three different episodes of Ask an Attorney. You on for three episodes of Ask an Attorney. That is amazing. Thank you so much, because IP is such a humongous topic, especially with AI being huge and work for hire. All those remote staffers, whether it is from Fiverr or a remote staffer, whether it's in India or in the Philippines or Latin American countries, like it's such a hot thing to do right now. And I love it personally. I've used it. But you need to know where you stand with them creating a brand or a logo or any other IP for you. So these are excellent questions that were answered. Thank you so much for being on this episode of Ask an Attorney with the Attorney's Guide. Thank you so much, David Sanker of Sanker IP. Out
thank
in
you very much.
California.
Glad to
You.
be here, and look forward to meeting with some of these folks.
Thank you so much. Take care, David. Bye bye.